right? Don't try to like skip over it, because I tried doing that when I was first reading these things. It did not help, because then I was more lost. And I had the facts wrong, I had the arguments wrong, I just had everything wrong. So when you're reading a case, sentence by sentence is what I recommend. Read the first sentence of that paragraph. Do you understand it? Good. If you do, then move on to the second sentence. Do you understand the second sentence then? All right, move on to the third. One step at a time. And if you run into, say, this sentence right here, Credit Nation moved for summary judgment. What is summary judgment? Do you guys know what summary judgment is?
Did they want to settle? It seems like they want to settle summary judgment. I don't know.
Are you 100% sure?
No, I'm not.
You're not sure, right?
Look up this.
Then look it up. Stop right there. Look it up. Don't lean over like, oh yeah, we'll get to that later. No, stop everything. Look it up. Because you can't move on to the next sentence unless you completely understand this first sentence or whatever sentence you're reading. So the ones with a laptop, tell me what you find online. What is summary judgment?
A judgment entered by a court for one party and against another without a full trial.
Yes. So Credit Nation moved for summary judgment, meaning, hey, judge or court, we don't need to go on with this case or this trial because the plaintiff has no claim. So let's just stop here and be done with it. If that happens, the plaintiff will not receive any damages, right? That's what they're moving for. Credit Nation moved for summary judgment, meaning, hey, court, let's just stop here. There's no claim, there's no valid claim that the plaintiff is bringing. So that's what they moved for. They moved for summary judgment on December 11, 2015. So it's roughly about what?
That's like years.
Yeah. So Credit Nation, and then on July 18, 2014, Magistrate Judge Clay Fuller issued his R&R on the summary judgment motion, and in the R&R, the magistrate recommended that plaintiff's sex discrimination case or claim be equitably told because the EOC misled plaintiff about the nature of plaintiff's rights under Title VII, and 2, defendant's motion of summary judgment be granted because plaintiff failed to show that the Credit Nation reason for terminating her employment was pretext for unlawful discrimination. A lot to unpack in that sentence, right? You're like, what the hell am I reading?
I agree.
So again, if you don't understand it, break it down, right? Because there it has 2 Roman numerals here. On top of that, search for the words that you do not understand. Don't stop and move on to the next sentence. Stop and look it up. Plaintiff's sex discrimination claims be equitably told. What is told? Anybody know what told means in a legal context, not told like a transit? No one has heard about it, right? So what does toll mean? Yes?
It has tolling. I'm assuming it's a part of that. Tolling is a legal doctrine that allows for the pausing or delaying of the running of the period of time set forth by a statute of limitations, such that a lawsuit may potentially be filed even after the statute of limitations has run.
What is statute of limitation?
How long you
How
have to
long
file
you have
it?
to-
Right. So tort cases in Georgia is 2 years. So accident occurs, you have 2 years to file a claim. Same thing with discrimination cases. For to file EEOC case, which means you want to go to the EEOC first for discrimination cases, you have 180 days. So what happened probably was that the person, the plaintiff, didn't fall within the statute of limitation. So to still make her claim or his claim valid, probably filed a claim saying, look, can we toll and extend that statute of limitation because XYZ reason? And they have to have a very good reason. Their reason was because the EEOC misled the plaintiff about the nature of plaintiff's rights under Title VII. So it sounds like the magistrate judge agreed with it, right? The second part is that defendant's motion for summary judgment, which we talked about, where defendant's asking the court, hey, let's just stop it here, be granted. Because the plaintiff failed to show that Credit Nation's reason for terminating her employment was a pretext for unlawful discrimination, which basically means that the plaintiff failed to show that there was any correlation between the termination and the sex discrimination.
And then I have a question. So when it comes to, if you go back up to Title VII of the Civil Rights Act of 1991, does a case automatically fall under the umbrella of a Civil Rights Act because the plaintiff or even the defendant is from the protected class? Or does it only fall under the Civil Rights Act if they are stating that a violation of that right has been?
So the Civil Rights Act of 1991 was massive.
Okay.
And just like how you saw codified laws, right? The Title I, Title II, Title III, Title V, there's a lot of titles. Title VII specifically talks about protected class members.
Right.
So that has to be under that. If you're going to bring a claim against another entity, you have to show what rule did you violate.
Okay.
When you speed, you get pulled over and you get a ticket written, right? What law did you violate? What law are we discussing and arguing about here? If you murder someone, what law are you fighting about? Obviously, murder statute or murder code, right? In this case, the person's saying, I have been discriminated. Okay, so what law are we discussing? What law did this entity or person violate? So Title VII is quoted or is used as the law. So when we talk about IRAC and other types of parts that you need to identify, we'll get into the rules section. But right now, I just want to get into the facts right now for you to digest that. You need to kind of highlight and understand and also note. The second part is the procedural history. How do we get to where we are today? Where did it all start from? On a court procedure-wise. Again, right now, the magistrature, which is the trial court, has agreed with the defendants here, it sounds like. But guess what? In the United States, you can appeal a decision. On August 1, 2014, plaintiff filed an objection, arguing that there are genuine issues of facts regarding whether accreditation's decision to terminate plaintiff was pretext for unlawful discrimination. And August 13, 2014, defendant filed its reply to plaintiff objection, and defendant did not object to the R&R running recommendation. So basically, you have to break down again, okay? So plaintiff was not satisfied with the court's opinion and argued that there is a genuine issue and that the person was terminated with the pretext of a unlawful discrimination. And then the defendant filed its reply to that objection, and the defendant did not object to the RRR's findings and recommendations. So basically, the plaintiff got shut down.
What's R&R?
What is R&R? Yes.
What is R&R?
We're supposed to look it up.
Again, I'm telling you, it's synchronous. You have to find ways to get things done on your own. When you go out, go ahead.
Report and recommendation.
Yes. So when you go out and you're assigned to do some sort of work in a law firm or corporate setting, you have to find ways to do it on your own. You can't, You can if you have a good supervisor who's willing to kind of walk you through and guide you, but the expectation is that you have to at least know how to find the answer. They can find you, try to look up these keywords. Like this past week, right, when you guys were doing the case law research, when someone asked, hey, what word should I use or where do I go? And I can give you some guidance, but the bulk of the work you have to find on your own, right? So R&R, what does it mean?
Report and recommendation.
Yes. So
What did you put in?
For any term that I'm trying to get a definition for that's specific to industry, I put R&R in law.
Okay.
Tolling in law.
Yeah.
So that way it only gives me the definition in the context of the law.
Okay. I did it first.
So, legal standard. When you read a case, they're always going to be talking about legal standard. After conducting a careful and complete review of the findings and recommendations, the district judge may accept or reject or modify a magistrate judge's report and recommendation. Here's your R&R. A district judge, here's a standard, shall make a de novo determination of those portions of the report or specify proposed findings or recommendations to which objection is made. Like, what the hell does that mean?
I get ready to say now we're going with, but I know I gotta look it up, but I don't know what the de novo is.
Look up what de novo
Right,
is.
I gotta look it up. Okay.
Yes, what is de novo?
It is deciding it's deciding the issues without reference to any legal conclusion or assumption made by the previous court to hear the case.
So basically they're saying de novo is they're gonna look at this case fresh. Without looking at what happened before, they're gonna look at it from brand new eyes, without knowing and hearing anything, we're gonna read this again, and what our opinion is. Now, look up standard of review or legal standards. There are multiple.
Is it Legal standard?
Legal standards and standard of review. There are multiple out there. When an appeals court is looking at the trial court's review of work, right, they're going to use different types of legal standards. De novo is one of them. You don't have to do this right now, but when you get a chance when you go home to look up those multiple types of legal standards, because it's good to know. Because again, when you read some of these case laws, other standards will pop up. So you need to understand what those legal standards are. Okay? This one is looking at de novo. If no party has objected to the report and recommendation, a court conducts only a plain error review of the record. So it's kind of reiterating what de novo means. You guys have soaked all this in so far right now? You're not overwhelmed yet?
No.
Okay, good. Trying to make sure that no one cries today. So, when briefing a case, so far I want you to know what the facts of the cases are. I need to know who the plaintiff and defendants are, right? The characters involved here, but most important, what the plaintiff and defendants. I also need to know what the standard of review is, if there is one. Because if we're looking at just a trial court case, there's no standard of review, right? It's only for appeals court cases or appeals cases. Lastly, procedural history. What happened? How do we get here today? When was it first filed, in which court, and what court are we in today with this case, right, when you're reading it? Write all those out, because when I say I need you to brief a case, you'll need to be able to write all that down.
Isn't that part of IRAC?
In whichever order you want, but I'll tell you which order it is later on, because I want to cover all the brief sections first.
Can you say this one more time what you just said? You said we want to know the plaintiffs?
Plaintiff and the defendant, or the names
Or
of the
characters,
parties.
right? Or you say
Yeah,
characters.
parties here. You need to know the facts of the case.
Facts, that's
So I
number
need you
one.
to tell me what the facts of the cases are. I hate copy and pasting. Tell me it in your own words. Because if you copy and paste it, the turn it in software is going to go berserk. You're like, oh, plagiarism. When you're just signing a big chunk of like whatever paragraphs, don't do that. In your own words, what happened? Right? We went through line by line today about these facts. Tell me what happened in your own words, right? You guys are now storytellers. Afterwards, I need to know procedural history. How do we get to where we are today? You know, are we in appeals court? Are we in Supreme Court? You know, did it start? Which court did it start in? Right? Is it Georgia District Court, Georgia Magistrate Court? Which court? Where do we start? And where are we today right now? So procedural history. Lastly, so far, and there's more sections you need to know, but right now, standard review. Standard review is optional. If we're in an appeals court case, standard review is going to be there. If we're just talking about reading a trial court case, standard review may not be there. So being cognizant, being aware of which court matters, because when you're doing the procedure history, it'll help you decide whether I need to look for a standard review or not. I'm not going to go over summary judgments there, because actually, I want to burden you with this. No, that's good. Because I just want to hit up. So, remember the two things, the equitable tolling and the grant of summary judgment. So, the court, the judge, gave that decision. When someone gives that decision, or when the court gives that decision, there are reasons on one why they did it. That's where the arguments lay. And that's where it gets hard. Because now you have to understand not only the facts, but also the legal aspect of this particular case. Now, equitable tolling. We know what equitable tolling is now, right? Plaintiff failed to exhaust her administrative remedies because she did not file a charge of discrimination with EEOC within 180 days of the last Discrimination Act. Now I told you it was 180 days. That first sentence they used, and guess what they did after that? What did they do?
Cited the case.
Yes, they cited the case. You got to get into the practice of citing a lot of these things over your sentences. Title VII's filing requirement is subject to equitable tolling under certain circumstances. Yes, she missed or he missed the 180-day statute of limitation, but however, it says Title VII's filing requirement is subject to equitable tolling under certain circumstances. And guess what they did again?
Cited the case.
Where did they get that idea from, right? Because statute of limitation, you missed it, you're out, right? But you're trying to argue, hey, you did not miss that timeline, deadline.
There's exceptions to the rule.
There's an exception to the rule. That's why you have lawyers. And the exception to the rule is cited or discussed and contemplated by this case right here, Bourne versus School Board of whatever, and then Federal Executive Center. And you're gonna notice, I told you we're in the 11th Circuit, which is a federal court. And so they're gonna use 11th Circuit. Whatever case that you're dealing with, that matters, because if you cite me 9th Circuit Court or 1st Circuit Court, it doesn't apply, because the jurisdiction is not the same. You're looking at relevant case laws that are within your own pool of cases. So if you're in 11th Circuit, you better find 11th Circuit Court cases. If you're in Georgia state law, then you better find Georgia state cases.
Now, I just had to do just a quick search of Watson versus Blue Circle, because I'm just curious to know what was in that case. And it's one of those yellow flag cases. So.
Caution.
So it's caution that it's either been overturned or it's on shaky ground,
Yeah.
more or less.
Or it could be green. We don't know. Remember I told you, this is an older case being 2008, 2009. Transgender, that sex, gender, it has changed,
Okay,
right? That's why it's probably yellow right now.
okay.
But it's a good eye that matters, because remember I told you, you want to use green cases just to be sure, right? But I'm sure back then it was green, probably turned yellow right now because of the changing laws. But I'm guessing this one right here, Bourne versus School Board, it's probably still green, because that one's about tolling a statute of limitations, which is, I think, is not going to change anytime soon. The limitations period under Title VII may be equitably tolled if the EOC misleads a complaint or complainant regarding the nature of his or her rights. Again, another citation. The magistrate judge concluded that the statute of limitations should be equitably tolled in this case because the EOC misled plaintiff regarding her rights by informing plaintiff that transgender persons cannot file for sex discrimination under Title VII. So they're saying, hey, she's allowed or he's allowed to toll or request for this equitable toll or tolling because the person was misinformed that they are not protected when they are in fact protected. So the EOC provided them wrong information, so thus he or she is entitled to an equitable tolling.
My overall sense is the plaintiff's got to have some money to keep going at this. Do you understand? Isn't this very expensive?
Plus a whole
That's
lot of
free.
money.
So if you are wrongfully terminated or if you have wrongful act at work, you first have to bring the matter with the EOC. The EOC is going to determine whether you have a case to move forward with or not. If they decide that you do have a case, then they'll recommend litigation and you file a claim in the state level circuit in this case. Because discrimination is what jurisdiction?
11th, right? 11th.
Because we're dealing with federal law.
Okay.
There's no state law regarding discrimination. It's all federal. So once that's filed, then you file a claim and you go to court. But if the EOC says we found that there's no claim, then you don't file. You can't really file. You can still go ahead and file, but your filing is not going to be as strong because EOC did their investigation and said we didn't find anything wrong. So you're already starting with like basically a broken leg at that point. So they're saying the EOC misled the plaintiff here, saying that you're not protected under Title VII. Because the person was misinformed, they're allowed to toll the statute of limitation. In that one paragraph, what we just talked about is in there. Remember I told you it's a whole new style of writing and reading and stuff? It's not your literary writing they used to do, it's literally technical writing. So everything they were claiming and arguing, everything they're trying to support was supported by another case. And then they go into more, dissecting it further. In Pricewater versus Hawkins, the United States Supreme Court held that discrimination on the basis of gender stereotype is sex-based discrimination under Title VII. Cited again. In other words, Title VII prohibits employers from discriminating against employees for failing to act and appear according to expenses defined by gender. Cited again. And then they have a whole more quote. So the reason I read that and just stopped right here is because when you're establishing an argument, you have to break it down even further. So first you're saying, okay, equitably told, fine. But to establish that you can equitably told the situation, what do you have to establish? Well, that the person is protected, right? Falls under the protection of Title VII. So they have to establish that aspect of it first before going into why it should be able to be told. So that's what it's doing right now. It's establishing the law first. Because then you can argue, well, because the law says you are protected, and then they're going to probably argue and use the fact that the person was misinformed as if that's not their mistake, it was the EOC's fault, thus they should be given extra time. That's what they're trying to argue against.
Now, during that time, though, you said, if I understood you correctly, that transgenderism was not...
It wasn't considered as like a big thing.
It wasn't a protected class?
Yeah, so I think the laws might have changed, or that started to change, because I forgot which administration it was. It was either, I think it was the Obama administration, when they started producing those type of changes. So I think in 2008 or 2007, procedure history, standard, legal standard, if there is one that is for this particular case. The next thing is making that analysis. What happened in this case? What are the arguments? What are the theses? What are the main focal points they're trying to prove, and how are they supported? Right? The way they're breaking this first prong out with stating what Title VII says, right, and then showing what happened in the fact, comparing the facts, and then showing what the exception rules are, with, different supporting cases, and then concluding that this is how it should be decided, and it was decided correctly, right? That's an analysis. You're comparing the law with the facts of the case. That is analysis. That's why knowing the facts is so important, because if you don't know the facts, then you cannot make the analysis with the laws that you find. Even when you read and find other case laws out there, you need to pull out that argument and facts like they're doing, right, to support your argument. If you can't bring out good facts and good cases that you find to support your argument that you're trying to make, then you don't really have an argument. We talked about the both sides of the coin, right? Like you were arguing for the company there for accreditation that was trying to give you perspective of the plaintiff. You have to think about all these different things and then try to put up an argument. Make that scope. That's the only original part of your writing.
Okay, but I'm making the argument for the plaintiff?
Huh?
I'm making my argument for the plaintiff?
Whichever side you're told to make an argument
Okay,
for.
okay.
Right? But you'll be assigned to cases where you either have to brief in a subjective manner or in a subjective way, or in an objective way. You're going to start out making an argument, probably have to look at the assignment, but most likely an objective point of view. What happened in this case? What are the arguments? What are the analysis? Or what is the analysis of this case, right? So the way I just showed you on how this is written is the way you need to write your analysis. If you need to summarize what happened in this case, I need you to break it down like how they broke it down here and made the arguments. Remember, use your own words. You can't write like this. Even I can't write like this sometimes, It's not easy writing. So if I see some sort of writing that comes out like this, I'm gonna know. I don't need to look at the Turnitin software I have. I'm gonna let you copy this from somewhere, right?
It could be legal savants.
And I showed you an example. For every argument they were making, they had something to back it up with. You guys have argued in the past, right? With your family, or your sisters, brothers, or friends. And key phrase is sometimes, can you back it up? Same thing, you have to be able to back it up. Your analysis uses the cases that you find, the rule that you're contemplating, right? And the argument you're making. All this applies under analysis. When you're doing an objective writing, you're just writing out what everything you said. When you're doing a subjective writing, you need to try to persuade me with the facts that you find and the supports that you find to support your argument. Questions? Yes.
Yes. My question is, okay, in the beginning when you were going through the facts, one of the things that stood out in my mind is the fact that she had called a reporter to let them know that she was going to reveal
That
her
was the first
transition
thing.
in the whole nine.
And you're my attention seeker? Yeah.
So the thing that I thought about was, okay, so once the case has been
So to cover again from the very top, I need to know the plaintiff and defendant, who are the parties. Tell me the facts of the case. I need to know the procedural history. And then afterwards, let me know if there's a legal standard or not, because depending on where you are in court, there's going to be one. And then I need you to do the analysis. Oh, one more thing I forgot, sorry. Before we get into the analysis, what is the overarching rule? In this case, what is the overarching rule? Title 7. Right?
Oh, okay, I didn't understand.
Overarching rule that we're discussing.
Okay.
If you're in a car accident, if you are in a situation where you use personal injury attorneys, the overarching rule, 100% of the time, is negligence.
Okay.
4 elements that you need to prove, right? If you're in a data privacy situation regarding GDPR or all that stuff, you need to have an overarching rule. Well, guess what? GDPR is going to be your overarching rule. You have a breach of contract, that there's going to be contract provisions or contract rules, that's going to be your overarching rule. If you murder somebody, you have an OCGA in the state of Georgia, that's going to be your overarching rule.
What's the OG?
OCGA,
Yeah.
that's the official code of Georgia.
Okay.
Like for the statute name.
Yeah, the
Okay.
statute, yeah.
Okay.
So, tell me what the overarching rule is before you get into the analysis. Rule section is what I call it.
That's 16-5, that's
So,
murder and felony.
when I say brief this case, again, parties, I need to know the parties. Second part, facts. Third, procedure history. Fourth, if there is a legal standard. Next is rule section, like tell me if what's the overarching rule. Now, overarching rule could be you can copy and paste it. That's one way of doing it. If you get it correct, that's great. What's even better is if you can break it down in your own words on different elements. Because we talked about a statute last week, right? How you can break it down into 3 different elements. If you can break it down in 3 elements, that's even better. So that's the rule section. What's the rule we're dealing with here? And then analysis. How you do the analysis, I just showed you the way they draft analysis. Comparing the facts of the case with the legal part of it, which is the rule, right? How does it apply? And then you may break down into a lot of subsections or sub-rules, right? Or not sub-arguments, because they may be dealing with multiple things. So for example, negligence, right, has 4 elements. You gotta prove all 4 elements. So you're gonna have 4 subsections. And then you can say, okay, this person was negligent. That's why when we break it down in different elements, if there's murder has 3 elements, then you have 3 separate paragraphs or 3 separate arguments that you can prove in that analysis. Because all 3 must be met in order for a person to be convicted, right? And then obviously, again, what I said, it was conclusion, right? What happened? What did the judge say? Like, what was the decision, right? You can say who won, but don't say who won. Just say the judge decided or ruled, the court ruled in whatever. So there are some key phrases you can use in the conclusion section. You'll get all that from a case law, because the case law will talk about it, right? And you just use that, parse out those words that you're using to formulate your own sentence on the conclusion. That's what I mean by brief case. In law school, we have to brief a lot of cases each week. I read about 500 pages a week. Each class about, I want to say 5 to 8 case briefs we have to do. So if you have 5 classes and you have 8, that's about 40 case briefs we have to do. Each week.
Was it group? Did you do it as a group or individually?
No, you did it on your own.
Okay.
Remember I told you about this? Didn't I tell you in the first week how someone hid a book in the library so no one else could get it?
Wow.
It's dog eat dog. Like, you're against everybody.
Wow. Okay.
Yeah, you're on your own. I mean, yeah, there's some group studies you do together for finals, but when you have an assignment like this, like, you're on your own. So briefing a case that's what I mean. To understand what the case I just read. When I say brief it, that's what I expect. Because there will be assignments in this class where I'll say, I just want you to brief these 2 cases. And if I say that, that's what I want to see. Now, you can also title it that way too. Parties, semicolon or colon, right? And then you can say, and then facts. procedure history colon. You can break it out into different sections like that. Because organization is very important. And if you're just briefing the case, for me to read how you read this case or what you picked out and how you're organizing on your own notes, that's how you do it. Why is that important? Because eventually, at the end of the class, one of your final 2 assignments is going to be drafting an IRAC. Boom. So you'll be getting this later on in the quarter. But IRAC form is how you write an answer to an exam or an answer to an issue that you're dealing with. If there is a legal issue that you need to address, this is the subjective writing that I was talking about, right? And in law school, this is how everyone writes their answers. There's the issue section, which I'll show you how to write. It's just the 1 or 2 sentences, but it's very compacted 2 sentences or 3 sentences, depends on what it is. And there's a rule section, which you're getting practice out of when I'm saying briefing the case, right? And there's the analysis section, which I kind of showed you what to do, right? When you're doing subjective writing to prove something, right, you have to do the analysis exactly the same way, but in a more subjective manner rather than objective. And then the conclusion, whether or not someone should be convicted of something, or there was a case of negligence, whatever the conclusion is, you have the conclusion statement you're drafting. So the ultimate goal, again, and I'm showing you, is IRAC. But in order to get there, you need to learn how to brief a case so that in each case that you're reading, you can utilize that for your own analysis when it comes to IRAC writing. Now, citation is something I need to cover. Next week is Thanksgiving week. It's time for family, but also I think it's time for a midterm. The midterm, and I believe we'll cover this next week, is going to be multiple choice questions regarding citation.
Oh, Lord.
So the case we just read, well, how do I cite this case? I kind of told you a little bit how to start.
The name.
Right now we have Chavez versus Credit Nation Auto Sales, right?
Year.
You probably saw, yes. So if I were to write this out, I'll probably write Chavez versus Credit Nation, either underline or italicized, right? It's either or, right here. Then comma, and at the bottom right here, you have 49F.supplement.3D1163, Northern District of Georgia, because that's what is federal court, 11th Circuit rate, 2014.
Where
Yes.
would we get that far
From the case that
from?
you're
Oh, okay,
reading.
it will be there.
Yeah.
Okay.
So in your midterm, for example, when you get that multiple choice question that you have to answer, they'll tell you which court you're in. They'll give you these information. It's like, oh, here are the parties. This is the court you're in. This is the year that it occurred, right? And then here are the pages. So that 1163, for example, is a page number. When you go to a law library, which I think you probably need to browse to a law library as part of this course, you've seen those old encyclopedia books. Imagine that covering an entire floor with it. It's just a big encyclopedia kind of type of place. Brown books, really boring colors, lime green, whatever, not lime green, it's like murky green, whatever it is, it's just lawn. They're all categorized in these type of codes. So when you're getting a midterm